This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
Are we doing the long one now?
Sure. Let's see, I don't think I can say the words John Hamm's balls in the opening and have YouTube like that very much, can I? So we have a case here that's been hanging around the court system for a while, poking out here and there, and finally exposing itself to adjudication. This is the case of Lawrence Schwartzwald versus Oath Inc. Sorry, Lawrence, Schwartzwald? I don't know. You're going to like this one. This is a case that involves a photograph of John Hamm and what looks like him wearing trousers in public without wearing any underwear. We do have the photograph. You will get to make your own judgment. Let's take a look. Plaintiff Lawrence Schwartzwald brings this action against defendant Oath Inc., which owns and operates HuffPost.com, alleging copyright infringement in violation of Section 501 of the Copyright Act. Schwartzwald asserts that Oath unlawfully reproduced a photograph he took of the actor John Hamm without seeking his authorization or paying a licensing fee. The photograph, which Schwartzwald, this is gonna get me. This is really, I'm gonna have to say all these syllables at the same time. The photograph, which Schwartzwald alleges illustrates what John Hamm looks like wearing trousers in public while he walks down the street ostensibly without wearing any underwear, was subsequently included in altered form in a Huffington Post article entitled 25 Things You Wish You Hadn't Learned in 2013 and Must Forget in 2014. Of course, it says 25 things you wish you hadn't learned. I don't know if that's a typo or not. Either party could be guilty there. Now before the court is Oath's motion to dismiss Schwartzwald's first amended complaint pursuant to the Federal Rules of Civil Procedure. For the reasons that follow, the court agrees with Oath that its use of the photograph is protected by the Fair Use Doctrine. Oath's motion is therefore granted. Schwartzwald is a New York-based professional photographer who licensed his... Schwartzwald is a New York-based professional photographer who licenses his photographs to online and print media for a fee. Schwartzwald took the photograph of actor John Hamm walking down the street while carrying a shopping bag and holding the hand of his then-girlfriend, the actress Jennifer Westfeld. Schwartzwald alleges that the photograph illustrates what John Hamm looks like wearing trousers in public while he walks down the street without any underwear. He further contends that he took the photograph for the purposes of commercial news reporting. So there's John Hamm, there's him walking down the street, but there's something going on here. There is definitely something going on here. I could not tell you what that is. I have literally stood here in front of my wife and tried to figure out, like, could that really be testicles? And I say no. I do not think that could actually be testicles hanging down that low. Like, all of the men who are watching this are right now, like, wondering how could they fall that low? Like, what is wrong with a person that they are that low? But okay, it's an interesting photograph. You really want to know what the heck is going on with John Hamm's balls. So that's where we are today. We are discussing John Hamm's balls in a copyright fair use case. Backing up. So that's the photograph for all to see. Schwartzwald licensed the photograph to Splash News and Picture Agency, a New York-based stock photography agency that sublicenses Schwartzwald's photographs to third-party media outlets. He also licensed it to the New York Daily News and other third-party media outlets for the purposes of commercial news reporting. On December 27, 2013, Oath ran an article on HuffPost entitled 25 Things You Wish You Hadn't Learned in 2013 and Must Forget in 2014. The article begins, 2013 will be noted for a number of positive, enlightening, and informative moments that took place across the cultural spectrum. People discovered, spoke truth to power, and risked their lives to get information to the public. But there was also a poop cruise, outrage over butt shaking, and E-list celebrities clinging to fame by doing porn. You were all right, 2013, but we could have gone without learning. The article proceeds to list 25 events or trends of 2013 that the authors could have gone without learning. Each event or trend is accompanied by a short paragraph of commentary. 12 are accompanied by photographs. Some of the items on that list, such as a former New York Congressman Anthony Weiner's explicit text messages, are salacious. Others, such as the discovery that dinosaur erotica is a thing that exists, border on the absurd. I mean, really? Rule 34? I mean, the court is now learning about Rule 34. Are you really? Really? Okay. A few, such as the contention that people freak out way more over TV deaths than they do over ones in the world we actually live in, are darker. A number of the items focus on viral moments involving celebrities, such as the assertion that the nation flipped a collective shit when pop star Miley Cyrus twerked in the MTV Video Music Awards. At issue in this case is an item in the list entitled, "Some Ad Men Don't Do Underwear." The text below the heading reads, "This year has been a busy one for Mad Men star Jon Hamm's privates. Apparently, he's very blessed south of the border, and he, or those who examine photographs of him, really want you to know that. Hamm says he wants people to stop talking about his loins, but it might help if he'd put on some underwear." Following the text is a cropped version of the photograph that excludes approximately half of the image, including the girlfriend with whom Hamm is walking. Superimposed over Hamm's groin area, the portion of the photograph that allegedly illustrates what Jon Hamm looks like wearing trousers without any underwear is a black box containing the words "image loading" in white text. Oath did not license the photograph from Schwarzwald, nor did it obtain his permission or consent to publish the photograph. Schwarzwald registered the photograph with the Copyright Office in 2017, more than 3 years after Oath published the article. The photograph was registered. The registration states that the photograph was first published in 2012. Schwarzwald alleges that he discovered Oath's article April 2018. So how does that work? Normally there's a 3-year statute of limitations in copyright. Well, we have the internet today, and so the article was still online, and therefore it's still being published continuously. Every time somebody makes an HTTP GET request for that article's URL, it's published again. Schwarzwald filed this action October 28, 2019, after Oath filed a motion to dismiss, etc., etc., etc. You know what? Skip the procedural history. To survive a motion to dismiss, a complaint must plead enough facts to state a claim that is plausible on its face. A claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. On a motion to dismiss, the question is not whether the plaintiff will ultimately prevail, but whether his complaint is sufficient to cross the federal court's threshold. In answering this question, the court must accept all factual allegations as true, but give no effect to legal conclusions couched as factual allegations. And I should note this is a 12b6 motion to dismiss for failure to state a claim. There are 6 others for a total of 7, I think. Section 106 of the Copyright Act grants copyright holders exclusive rights to reproduce the copyrighted works in copies and to prepare derivative works based on the copyrighted work. Yet, from the infancy of copyright protection, some opportunity for fair use of copyrighted materials has been thought necessary to fulfill copyright's very purpose, to promote the progress of science and useful arts. And we'll note this is also the way free speech gets incorporated into copyright, is through fair use. While the origins of the fair use doctrine lie in the common law, it is now codified in Section 107 of the Copyright Act. Congress meant Section 107 to restate the present judicial doctrine of fair use, not to change, narrow, or enlarge it in any way, and intended that courts continue the common law tradition of fair use adjudication. See, even the court can't go without saying the word enlarge in a story about Jon Hamm's balls. Section 107 permits the unauthorized use or reproduction of a copyrighted work if it is for purposes such as criticism, commentary, news reporting, teaching, scholarship, or research. The statute lists 4 factors for determining whether the use made of a work in any particular case is a fair use. 1, the purpose and character of the use, including the commercial or not-for-profit purpose. 2, the nature of the copyrighted work. 3, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. 4, the effect of that use on the potential market for or value of the copyrighted work. The task of analyzing fair use is not to be simplified with bright lines. There are no quick rules. There are no shortcuts. You must analyze every fair use case by case with a brand new, full-on fair use analysis. The ultimate test of fair use is whether the copyright law's goal of promoting the progress of science and useful arts would be better served by allowing the use than by preventing it. Fair use is an affirmative defense, and therefore defendant bears the burden of showing that a given use is fair. An affirmative defense may be adjudicated on a motion to dismiss where the facts necessary to establish the defense are evident on the face of the complaint. Accordingly, when the only two pieces of evidence needed to decide the question of fair use are the original version and the allegedly infringing version, it is proper to decide the issue on a motion to dismiss, citing Cariou versus Prince. Having considered each of the four fair use factors and weighed them together, the court finds that Oath's use of the photograph constitutes a fair use. Dun dun dun! The first factor, the purpose and character of the use, involves three sub-factors which involve determining whether the use is 1, transformative, 2, for commercial purposes, and 3, in bad faith. The inquiry may be guided by the examples given in the preamble to the fair use section, looking to whether the use is for criticism, commentary, news reporting, and the like. The central purpose of this investigation is to see whether the new work merely supersedes the objects of the original creation, or instead adds something new, with a further purpose or different character, altering the first with new expression, meaning, or message. Transformative works lie at the heart of the fair use doctrine's guarantee of breathing space within the confines of copyright, and the more transformative the new work, the less will be the significance of other factors like commercialism that may weigh against a finding of fair use. Oath's use was transformative. Copying from an original for the purpose of criticism or commentary on the original, or provision of information about the original, tends most clearly to satisfy Campbell's notion of the transformative purpose involved in the analysis of Factor 1. Courts often find such uses transformative by emphasizing the altered purpose or context of the work as evidenced by surrounding commentary or criticism. Thus, display of a copyrighted image or video may be transformative where the use serves to illustrate criticism, commentary, or a news story about that work. That's important. Go watch our Good Mythical Morning videos where Leibowitz had a really strong case, I think, against Good Mythical Morning, but he botched it. But the underlying claim, I think, was sound, that you could not use a third party's photograph to illustrate a news story about the subject of the photograph, not the photograph itself. For example, a news report about a video that has gone viral on the internet, it's internet and might, so that is internet. For example, a news report about a video that has gone viral on the internet might fairly display a screenshot or clip of that video to illustrate what all the fuss is about. Similarly, a depiction of a controversial photograph could be fair use as accompanying and commentary about the controversy or criticism of the photograph. On the other hand, if a photograph is merely used as an illustrative aid and depicts the subjects described in an article, it does not constitute transformative use. That said, the copyright law imposes no requirement that a work comment on the original or its author in order to be considered transformative, and a secondary work may constitute fair use even if it serves some other purpose other than those, criticism, comment, news reporting, teaching, scholarship, research, identified in the preamble to the statute. Oath contends that its use of the photograph was transformative because the superimposed text box, photo caption, title, and broader context of the article fundamentally transformed the character and purpose of the use. Unlike the original photograph, which plaintiff claims had the original purpose of illustrating what John Hamm looks like wearing trousers in public while he walks down the street ostensibly without any underwear, Oath's use of the photograph served the dual purpose of mocking both Hamm and those who found the photograph newsworthy in the first instance. The text box with the words "image loading" in all caps, a play on words that alludes to both the nature of the digital technology and the body part at issue, suggests that Oath is making fun of Hamm, not merely illustrating illustrating his appearance. Moreover, as described above, the headline of the article, 25 Things You Wish You Hadn't Learned in 2013 and Must Forget in 2014, makes clear that the broader purpose of the article is to poke fun at events, trends, or topics that went viral in 2013. The text immediately preceding the photograph reinforces the court's conclusion that the article aims to mock the public fixation on Hamm's privates in addition to mocking Hamm itself. It states, "This year has been a busy one for Madman John Starr Hamm's privates. Apparently, he's very blessed south of the border, and he, or those who examine photographs of him, really want you to know that. Hamm says he wants people to stop talking about his loins, but it might help if he'd put on some underwear." The caption thus twice references the public's focus on revealing photos of Hamm. First, by describing those who examine photographs of Hamm, and second, by declaring that Hamm says he wants people to stop talking about his loins. This caption, when viewed in the context of the article's larger focus on viral moments, demonstrates that Oath used the photograph in part to mock the fact that the photograph went viral to begin with. The court thus concludes that the derivative use of the photograph in Oath's article served two purposes that are distinct from that served by the original photograph. Oath's use of the photograph was transformative because Oath modified the very portion of the photograph that made it most valuable or unique in the first instance. So they blacked out the heart of the work. By superimposing a text box over Hamm's groin area, Oath obscured the specific part of the photograph that allegedly reveals that fact. A reader of Oath's article would thus not be able to see the very thing the photograph purportedly illustrates beneath the strategically placed text box, and what sets the photograph apart from most other photographs of Hamm. Accordingly, unlike Schwarzwald's photograph, Oath's photograph is not illustrative of what John Hamm looks like wearing trousers in public while he walks down the street ostensibly without any underwear. Rather, it seeks to conjure up this image in the reader's mind through the comedic placement of the text box. These distinctive features of Oath's use of the photograph set this case apart from several others in this district in which courts have found that derivative uses of photographs were not transformed by modest alterations to the originals. In Graham v. Prince, for example, the court held that a photograph was not transformed by the defendant's addition of an Instagram box. Similarly, in North Jersey Media Group, the court held that a photograph was not transformed when the defendant superimposed the text "Never Forget" over an image of the Twin Towers from September 11th. In contrast to those derivative uses, Oath did not simply add a border, hashtag, or make another minor alteration to the photograph. Instead, as described above, it cropped approximately half of the image and superimposed a comedic text box over the key portion of Hamm's groin area, placed a witty caption above the photograph, and placed it within the context of a larger article about viral moments or trends. Oath's use of the photograph is also distinct from the defendant media company's use of celebrity photographs in Barcroft Media. There, the defendant used the plaintiff's copyrighted photographs of celebrities in articles on defendant's celebrity gossip websites. For example, it used one photograph of the singer Selena Gomez in a gallery of 25 images showcasing a risque fashion trend described by the defendant as underbutt fever. It used another photograph of the actress Amanda Bynes in an article entitled "Amanda Bynes is Alive and Well in Mexico and in a Bikini," which commented on the actress's appearance and sought to demonstrate her improved health after a stint in rehab and turbulent behavior on social media. The court there held the defendant's use of the images has no transformative effect because it displayed the images in the same manner and for the same purpose as they were originally intended to be used. Paparazzi photographs are designed to document the comings and goings of celebrities, illustrate their fashion and lifestyle choices, and accompany gossip and news articles about their lives. The purposes for which the defendant used the images to serve as banner images and thumbnails for daily bumps of celebrity news, to accompany articles about celebrity gossip and human interest stories, and to be included in roundups of celebrity fashion trends are all consistent with the original intent behind taking and copyrighting the images. The court found that the defendant did not use the copyrighted photographs to illustrate criticism, commentary, or news story about the photographs in a way that a news report about a video that has gone viral on the internet might fairly display a screenshot or clip from that video to illustrate what all the fuss is about. Instead, the court held the defendant used the images as illustrative aids because they depicted the subjects described in the articles. If Oath had used the photograph simply as an illustrative aid in a celebrity gossip story, for example, by publishing an article focusing on the relationship between Hamm and his then-girlfriend, it would likely not be entitled to a fair use defense. Yet, as described above, Oath's article was not a typical celebrity gossip story, but instead was intended to be a comedic compilation of and commentary about viral moments or trends from 2013, including the viral photograph of Hamm. The use of the photograph here is more akin to the defendant media company's use of a photograph of the financier Don Rokind and his girlfriend in Yang v. Mike Network. The photograph in Yang initially appeared in a New York Post article entitled "Why I Don't Date Hot Women Anymore." The defendant media organization published an article entitled "Twitter is Skewering the New York Post for a Piece on Why a Man Won't Date Hot Women." That featured a screenshot of the New York Post article, including a portion of the photograph of Rokind himself, as well as a series of embedded tweets that mocked both the Post and him. The court noted that the tweets embedded in defendant's article not only poke fun at Rokind as he is depicted in the photograph, but also the idea that his opinions on hot women would be reported seriously in the way the Post has done. The court thus found that the defendant's use of the article constituted fair use, as the article was used to illustrate what all the fuss is about, namely the Post article and its depiction of Rokind. I'm going to go with Rokind. Rokind. Let's go with that. Which was a different use of the photograph than the Post's. Here, too, the photograph was used to illustrate what all the fuss is about, namely Hamm's privates and the public's fixation with them, which is a different use of the photograph than that intended by Schwarzwald. Although the Oath photograph arguably constitutes a parody of the original photograph as well, this presents a closer question because parody needs to mimic the original to make its point. In light of the court's holding that Oath's use of the photograph was transformative for the reasons identified above, it need not reach Oath's alternative argument that it's a parody, nor Schwarzwald's response that the Oath photograph cannot be a parody because it involves a reproduction as opposed to a recreation or imitation. In any event, in spite of his attempts to draw a distinction between reproductions of original works and recreations or imitations thereof in the context of parody, Schwarzwald appeared to concede at oral argument that courts can find transformativeness out of an alteration of an image outside of parody. Rightly so, as numerous Second Circuit cases have found secondary works transformative, notwithstanding the fact that they contained modified reproductions of photographs. And then they go on to cite Cariou versus Prince and Blanche, and we'll skip that because we read it above. In short, while the court need not opine on whether the Oath photograph constitutes a parody, there should be no dispute that the fact that Oath reproduced the photograph in modified form does not itself defeat a finding of fair use. In sum, the court finds Oath's use of the photograph was transformative because it used the photograph in service of its dual goals of mocking him. No, it says Hamm. In sum, the court finds Oath's use of the photograph was transformative because it used the photograph in service of its dual goals of mocking both Hamm and those who fixate over such suggestive photos of him, a use distinct from that which Schwarzwald intended, and because Oath obscured the very portion, or heart, of the photograph that made it most valuable and unique in the first instance. Oath's use of the photograph for commercial purposes, so the second part of the first factor of the fair use inquiry. Schwarzwald alleges that Oath is a for-profit entity that republishes the photograph on its website for the purpose of commercial news reporting. While the court expressed no view on whether Oath's article could fairly be characterized as news reporting, it finds that Schwarzwald has It finds that Schwarzwald has plausibly alleged that Oath used the photograph for commercial purposes. Oath does not appear to dispute that it is a for-profit entity, but rather contends that this sub-factor should not weigh heavily on the court's fair use determination. Indeed, as described above, if the new work is substantially transformative, the other factors, including commercialism, are of less significance. Accordingly, the court finds that this sub-factor counsels against a finding of fair use, but is not entitled to significant weight, given that Oath's use of the photograph was transformative. Oath did not engage in bad faith. As to the third sub-factor, the court finds no plausible allegations of bad faith here. The mere fact that Oath reproduced the photograph without seeking Schwarzwald's authorization does not lead to a finding of bad faith, as the Second Circuit has noted, that it is aware of no controlling authority to the effect that the failure to seek permission for copying in itself constitutes bad faith. In any event, bad faith is not itself conclusive of the fair use question or even the first factor. In sum, the court finds that 2 of the 3 sub-factors regarding the purpose and character of the use weigh in favor of a finding that Oath's use was fair, and that the only sub-factor that counsels against fair use was not entitled to significant weight. The nature of the copyrighted work calls for recognition that some works are closer to the core of intended copyright protection than others, with the consequence that fair use is more difficult to establish when the former works are directly copied. So we recognize that some works extend to the core of copyright protection. The Second Circuit has identified 2 relevant sub-factors, two hanging sub-factors to be considered in this analysis, whether the work is expressive or creative, such as a work of fiction, etc., or whether a work is published or unpublished, with the scope for fair use involving unpublished works being considerably narrower. Currently, Richard Hogue is dealing with this and the Sony leaks of Last of Us 2, so they were unpublished, so less likely to be fair use. Likewise, that first fair use factor, a greater leeway being allowed for a claim of fair use on factual works or informational works than on creative works. As to the first sub-factor, the parties dispute whether the photograph is a creative work or a factual work. Schwarzwald contends that the photograph is creative in nature, as it is the product of a professional photographer. Moreover, according to plaintiff, in creating the photograph, he exercised a personal and creative choice in the selection of camera equipment, wide-angle lens, perspective, angle, lighting, and exposure. Oath, by contrast, argues that the photograph is of a more candid and factual point-and-shoot nature than a posed or creative one, particularly in that it was taken for the purportedly objective purpose of reporting, specifically to illustrate what John Hamm looks like wearing trousers in public while he walks down the street ostensibly without any underwear. The court agrees with Oath that the photograph is more factual in nature than creative. The photograph is a standard, paparazzi-style photograph of a celebrity walking in public and is thus similar to the photographs at issue in Barcroft Media. There, the court noted, the photographers predominantly captured their subjects in public as they naturally appeared and were not tasked with directing the subjects, altering the backdrops, or otherwise doing much to impose creative force on the images or infuse the images with their own artistic vision. Although photography, including photography of a celebrity walking around in public, certainly involves skill and is not devoid of expressive merit, the images are further from the core of copyright protection than creative or fictional works would be. Here too, Schwarzwald appears to have captured Hamm and his female companion as they naturally appeared without altering their poses or staging their surrounding environment. The photograph at issue in Yang, by contrast, was a posed photograph of Rockhind and his girlfriend. The Yang court thus found that it evinced at least a modicum of artfulness sufficient to designate it as a creative rather than factual work for the purposes of a fair use analysis. The second sub-factor, whether the work is published or unpublished, also weighs in favor of Oath, as Schwarzwald's copyright registration states that the photograph was first published July 9, 2012. Accordingly, even drawing all inferences in Schwarzwald's favor, the nature of the copyrighted work points towards a finding of fair use. The amount and substantiality of the portion used also weighs in favor of a finding of fair use. The relevant inquiry is whether the quantity and value of the materials used are reasonable in relation to the purpose of the copying. The law does not require that the secondary artist take no more than is necessary. Instead, the secondary use must be permitted to conjure up at least enough of the original to fulfill its transformative purpose. Here, contrary to Schwarzwald's claim that Oath reproduced the photograph with only minor cropping, Oath published approximately half of the photograph. Oath's cropping eliminated Hamm's girlfriend from the photograph entirely. Perhaps more important is the fact that Oath superimposed a text box over the very portion of the photograph that Schwarzwald claims made it noteworthy in the first place, Hamm's privates. Oath's use thus contrasts with the defendant's use of the photograph of Selena Gomez in Barcroft, in which the defendant did crop out some of the background of the photograph and portions of the singer's body, but nonetheless focused on the portion of the image most likely to grab viewers' attention and induce consumers of celebrity gossip and fashion trends to view the image, namely Gomez's risque fashion choice. Accordingly, it was a reasonable use of the photograph to achieve the purpose of both identifying the object of controversy and satirizing Hamm and those who fixate on similar photos of him. Schwarzwald suggests that Oath could have pursued several alternatives, all of which he argues would have achieved its objectives without violating his copyright. They could have commissioned their own photographer to photograph Hamm, they could have published a news story without the photograph, or they could have obtained a license. The first and second alternatives, however, would not employ a photograph of Hamm's privates that had already gone viral and thus would not have accomplished Oath's goals of mocking both Hamm and those who obsess over viral photographs of this sort. As Oath put it, the fact that people were so interested in photographs of John Hamm and his privates, such that they made news, is precisely the subject on which the article is commenting. Oath could not have communicated the same message without using the photograph or a similar photograph of Hamm's privates that had already made news. Schwarzwald's third proposed alternative, licensing the photograph, is circular. While Oath could, of course, have sought a license from Schwarzwald to publish the photograph, it was only legally obligated to do so if its use of the photograph did not constitute fair use. Accordingly, the fact that Oath did not seek a license does not in itself defeat its fair use defense. The fourth fair use factor, the effect of the use upon the potential market for or value of the copyrighted work, is undoubtedly the single most important element of fair use. When a secondary use competes in the rights holder's market as an effective substitute for the original, these are keywords, it impedes the purpose of copyright to incentivize new creative works by enabling their creators to profit from them. This factor focuses on whether the copy brings to the marketplace a competing substitute for the original or its derivative, so as to deprive the rights holder of significant revenues because of the likelihood that potential purchasers may opt to acquire a copy in preference to the original. Factor 4 is necessarily intertwined with Factor 1. The more the objective of a secondary use differs from the original, the less likely it will supplant the commercial market for the original. The fourth factor here weighs in favor of a finding of fair use, as Oath's use of the photograph is transformative, and it is unlikely that any potential purchasers of the photograph would opt for Oath's version instead of the original. As noted above, Schwarzwald alleges that he licensed the photograph to third-party media outlets for the purposes of commercial news reporting, as the photograph illustrates what John Hamm looks like wearing trousers in public while he walks down the street, ostensibly without any underwear. The risk is low that any media outlet seeking to report on this fact would use Oath's photograph instead of Schwarzwald's, as the superimposed text box makes it impossible to ascertain what John Hamm looks like without any underwear. Oath's alterations of the photograph render this case distinct from Barcroft, in which the court found the defendant had failed to show that the general audience for paparazzi and human interest photographs would not be equally satisfied with its versions of the relevant photographs. Because Oath's use of the photograph obscures its central feature, the secondary use does not constitute a competing substitute for the original and will not deprive Schwarzwald of significant revenues. The Supreme Court has instructed that to ascertain whether the use is fair, all four of the statutory factors must be weighed together. As described above, Oath's use of the photograph was transformative. There is no plausible allegation of bad faith. The nature was factual, not creative. The photograph was already published. The amount that was used is reasonable, and it is implausible that Oath's version of the photograph will supplant the commercial market for the original. The only sub-factor that weighs against a finding of fair use is the fact that Oath used the photograph for commercial purposes. Yet, as described above, this factor must be applied with caution, and is of less significance in light of the transformativeness of the use. Weighing the statutory factors together, the court concludes that Oath's use was fair as a matter of law. For the foregoing reasons, the court holds that Oath's use of the photograph constituted fair use and grants Oath's motion to dismiss, as Schwartzwald already amended his complaint once in response to Oath's initial motion to dismiss and, in the absence of any indication that he could or would, provide additional allegations that might lead to a different result. The first amended complaint is dismissed without prejudice. The clerk is respectfully directed to terminate the motions and close this case. That is Judge Ronnie Abrams, United States District Judge for the Southern District of New York. I thought you guys would really like to have a reprieve from all of our Leibowitz coverage, and fortunately we were able to find a fair use case in the Southern District of New York. That is, of course, a Richard Leibowitz case. So, boom, pulled one over on you. So what do you think of that? That is a great explanation of the difference between fair use and not fair use again. And of course we have John Hamm and whatever he was carrying in his pocket. I as a man, I personally don't think that those were his actual testicles, and rather he had some Chinese, massage balls or whatever in his pocket or something. Or maybe he had a couple bouncy balls for his girlfriend to play with later or something. I can't imagine that that's actually as low as his actual testicles hang. But I'll leave that to somebody else to know. I really don't want to know. As beautiful a man John Hamm is, I really don't need to know whether his... Don't want to visualize that. Let me know what you think in the comments below. Let me know what you think in the comments below. Yeah, hang it out down there. Air dry it out down there, right? So thanks for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal education show here on YouTube, on Floatplane, and on Twitch. This is a community-supported legal education channel, meaning we need your monthly support on patreon.com/ljfrench or sponsus.com/law to keep our efforts going. Thank you very much in the month of September to the following $50 plus supporters: Joe Tyson, Wes Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Benjamin Hitov, Steven, Cute Grills in Your Area, Longreach Jones, Goliath Cleric, Ugly Grill, Shielo T, Rudolph Bescherer Jr., Oscar the Phrophet, Jay Dixon, Hot Grills in Your Area, Ameknight, Engi, Torpedan, Brandyn, Abel, Cassandra, Curran, and IANAL, or I Am Not a Lawyer. Thank you very much to the $5 plus supporters that are scrolling on the screen in front of me. I will see all of you in the comments to the videos. Please don't forget to like, subscribe, and share, and help us grow the channel. I love you all. I will see you later. Bye. Ah.